All right, good afternoon, everyone. Thank you for joining today's online presentation entitled Moving Forward with Healthcare Reform. The ball is back in your court. Starting things off today, we have David Blumenstein, our National Director of Multi-Employer Consulting.
Thanks a lot, Sean. On behalf of all of us at Segal, I want to welcome you and thank you for taking time out of your busy schedules to spend some time with us today to talk about what is required of Taft-Hartley funds in the wake of the Supreme Court ruling about the constitutionality of the ACA. And to do that, I am delighted to introduce three of my colleagues, all experts in different aspects of how the ACA applies to your fund and the impact it will have on your fund participants. They have well over 50 years of experience in working with multi-employer plans. First, we have Kathy Bakich. She's a Senior Vice President and the Health Compliance Practice Leader for Segal. Kathy has been at the forefront in trying to understand how the ACA affects multi-employer plans from a compliance and practical implementation perspective, as well as working with the federal government to try to change the ACA to be more friendly to multi-employer plans. Second, we have Andrew Sherman, Senior Vice President who leads our multi-employer health practice and is an expert in multi-employer benefit plan design, compliance, and funding. And Josh Meyer, a consultant in our communications practice, who is expert in multi-employer plans and how to communicate about them and the issues that come with multi-employer plans and how to communicate those to plan participants. So let me just go through, give you a brief rundown of today's agenda. First, we'll talk a little bit about the Supreme Court's decision. Then we'll do a review of the legislative and regulatory outlook. We'll look at the state exchanges and what's happening with them and other provisions that are in play as well. And we'll give you some practical advice about how to construct some of these issues into an agenda for fund meetings as they come up over the next several months. And last and certainly not least is communicating ACA. But before we begin with the formal agenda, I want to touch on 3 points. The first one is that the Premium Assistance Tax Credit, which is the low-income tax subsidy, is very important to many of our clients. It's so important and complex, in fact, that we will be hosting a separate webinar on this topic. We might mention it in passing on today's call, but we will not be handling that in depth. The second thing is that ACA is a sweeping law, and it may hold down costs in the long term, but it doesn't really hold down costs in the short term. A couple of months ago, we actually gave a presentation on just that element, so we will really not be reviewing that again with you again today. If you want to see a copy of that presentation or want to have a discussion about it, we're certainly happy to do that offline. And third, and certainly not least, regardless of the Supreme Court's recent ruling about ACA, it is still a political football, and the Segal Company really has no view about this other than the ACA is the law, and we will be giving you our view about how to comply, not if to comply. So if there's only one thing that you remember from today's presentation, I would hope that it would be this. We want you to know that Segal is here to help you comply with ACA, and there is a lot to do to prepare for it, and that's what we're going to be talking about in the next 50 minutes or so. So again, thank you for joining us today, and with no further delay, I'll now turn over the presentation to Kathy Bakich.
Thank you, David. As you all know, the ACA was passed in March of 2010 as part of two bills. There was a Senate bill and a reconciliation bill. And only a few hours after the law was signed, the lawsuits started being filed challenging parts of the act. The focus of the lawsuits was a challenge to the individual mandate and the expansion of Medicaid. Specifically, the lawsuits alleged that the individual mandate requiring individuals to have minimum essential coverage or pay a penalty when they file their tax returns was unconstitutional. The lawsuits alleged the entire statute needed to be declared unconstitutional. However, the Supreme Court appointed special counsel when they heard the case to address whether the entire law had to be thrown out or whether only portions of the law were affected. In addition, the Supreme Court appointed special counsel to address whether a law called the Anti-Injunction Act prevented the court from deciding whether the penalty was constitutional because no one had yet been assessed the penalty. Finally, the court addressed in its oral arguments whether the expansion of Medicaid in the Affordable Care Act was constitutional. Before we look at the outcome of the case, I wanted to spend a little time talking about what was actually challenged.